colleague, Davita Dotson.
Good morning. I'm Davita Dotson, and I work in our family law unit. And I just wanted to start out, as I understand it, everyone here is in the helping professions. So I just wanted to start out with a quotation from Maya Angelou. I've learned that people will forget what you said, people will forget what you did, but people will never forget how you made them feel. And an advocate's greatest resource is their empathy. So next slide, Chloe. Can we change the slide? Can you guys hear me?
We can hear you, Davita.
Okay.
The slide.
Okay, so what is domestic violence? Domestic violence is a pattern of behavior by the perpetrator used to gain power and control over the victim. And in many cases, not just physical violence, the abuse will use physical violence to emphasize and increase the impact of emotional, financial, or psychological abuse. So what causes domestic violence? Domestic violence is a learned behavior. It's learned many times through observation and later through reinforcement. And that would include the reinforcement of the domestic violence of this learned behavior is when the legal system fails to hold perpetrators accountable for their actions. So one of the slides that I provided for you has to do with fatalities in Ohio, and I thought you might find this interesting because this is a very recent calculation. And so this slide talks about how in a year's time there were 109 fatalities in Ohio. And there were 77 individual incidents, resulting in 71 of the victims of domestic violence and also 38 who were the perpetrators of the domestic violence. So one of the very common things that happens in these cases is that there is the murder of the family member, and then afterwards there is a suicide. Next slide, please. So I also just wanted to talk about some of the other things that folks experience. Some of our clients have been abducted, and also just it's important to understand that police officers have also been killed in these incidents, and one of the police officers died in this recent year review. So can we go to the next slide? Okay, thank you. So I just wanted to talk about some of the behaviors of the perpetrator towards the survivor. And a lot of times I'll talk about someone who experiences domestic violence as a survivor. Usually there's a pattern of behavior, and many times there's a long-term pattern. So sometimes it starts out with emotional abuse, putting down the partner by telling them that they're not worth anything, they can't find a job to support themselves, calling them names, the B word, the other words that folks use, and making them actually think that there's something wrong with them, or being told that they caused the incident of domestic violence. And so these are like some of the methods that occur, and this would be definitely emotional abuse. Another thing that we look for, like when we make our assessment, is the whole issue of isolating the survivor or the victim of crime. So because this is a pattern of behavior, many times the survivor is cut off from their friends. Sometimes the person is not allowed to work. Maybe they're cut off from their families. And so again, it's an issue of control, an issue of coercive control is sometimes the word that is used. What else happens with respect to the behavior? Minimizing or denying that the domestic violence happened. Oh, I just pushed you, or that was just a tap, or that didn't happen. What's wrong with you? So using a method of minimizing and denying. Also, sometimes a perpetrator will use children as a way of controlling their partner. They may say, I'll get custody, or I'll take the children away, or you won't see the children again. Or perhaps, and this is actually one of the things that folks look for in assessments, saying they're going to kill their pet, actually hurting their pet. And then using economic abuse is an issue. I can't tell you how many of our clients, they don't know what their partner earns. They don't have access to a bank account. They're given kind of a limited, they're given kind of a limited amount of money, and oftentimes it's not enough money for groceries or necessaries, and so they can't save any money or put any money behind. And then finally, actual physical violence or threats of violence. Okay. So another thing that I wanted to talk about as far as doing, kind of assessing how serious the situation is, strangulation and sexual assault. So it's very important when you're working with a survivor that you encourage the survivor to talk about their issue from their own point of view so that they have an opportunity to tell their story. But it's also sometimes important to ask questions. So one of the things that there's kind of a lot of research in recently is the issue of strangulation. And it's important to think about if one of your clients tells you that they've experienced strangulation, it's important to ask some questions about that. And first of all, I think one of the things that I would say is strangulation is different than choking. Sometimes folks will say, well, he choked me. But if you're choking, you have something obstructing, you have like food in your throat or something like that. But strangulation is actually application of pressure to the neck that restricts the blood vessels and the air passages. And depending on the circumstances and whether there are some physical symptoms from it, many survivors actually need to seek medical attention even after it happens. So while there might not even be marks on the neck from the pressure or for the problems that the person might be experiencing, and actually most of the time, but there might be other physical signs like hoarseness or some of these things. And it's very important that that survivor of the violence actually check that out medically, because sometimes there are very serious medical consequences after strangulation. So another thing that I'd like to talk about, maybe the next slide, is what do we do about helping someone who has a domestic violence situation? And I think the most important thing when you have that first time that you meet with someone who's a survivor is that you develop a safety plan. And in that safety plan, it's important to let them know, hey, when they go to work or when they visit their family or when they go to the grocery store, see if in these times where they're worried about their safety, that they don't go alone, that they try to find ways that they have friends or family near them. And what happens in that situation is that many people will not commit an act of physical violence or a threat of violence in front of another person, so that makes them safer. or also, sadly, if they go ahead and do this in front of another person, then there is a witness to the domestic violence, and so pressing charges is easier. So along with trying to help your folks not be alone and for them to go places, is helping them plan for leaving. So leaving or terminating a relationship is the most dangerous time for domestic violence. And sometimes people judge survivors of domestic violence, and they think, well, why did that person stay? I mean, that person hit them or that person broke their arm. And so they think, why did they stay? But they stayed because maybe it's safer for them to stay, because the research has demonstrated that leaving the person or talking about leaving the person or actually leaving them is the most dangerous time. So other issues to think about in a safety plan might be packing a bag and leaving it with a trusted family member or a friend, making sure that there's money, there's their identification, they have their medicines, they have their important papers, clothing, but planning ahead so that they can so that they can be independent from the perpetrator. So then I wanted to talk about the civil protection order. That is a remedy that we offer in certain circumstances to survivors of violence. And so one of the things that's important to remember with a CPO is that it's a two-step process. It's not just something that you apply for and you file. There's usually 2 hearings associated with a civil protection order, and you have to prove certain elements to be able to actually obtain your civil protection order. So we really encourage folks who make referrals for civil protection orders to actually refer to legal aid first before you file it, because sometimes there are serious consequences to a survivor if they're not able to prevail when they file a CPO. So we recommend that you call us first so we can check out to see if it's legally sufficient. So when you try to do a civil protection order, when Howard and I do file one in court, what do we have to show? Well, we have to prove that a person has actually caused or is trying to cause a physical injury, or they're placing someone in fear of imminent serious physical harm. And courts have different requirements. All the different courts, sometimes it's easier to get one with one magistrate than another, or one county with another. And so sometimes it can be really rather technical getting a civil protection order. So we even have a presentation. Just because you can doesn't mean that you should with respect to civil protection orders. Because if you have children in common, sometimes courts will think that you're trying to obtain some kind of legal advantage by filing the protection order. And that's why it's very, very important that you can actually prevail if you're thinking about facing any kind of custody battle. So another remedy that we sometimes offer at Legal Aid is we do a divorce. As a matter of fact, I think probably we more often do a divorce in a domestic violence situation to stop the violence. It's kind of a clear message to the other person that they want to terminate the relationship. And of course, if there's children involved, then the courts are going to be looking at the behaviors of both the survivor and the perpetrator. And then finally, sometimes the victims or the survivors of domestic violence are children. So we also sometimes do custody cases in juvenile court where the victim of the violence is the child. And then just one other type of domestic violence that I want to mention, we do civil protection orders in these cases too, is sometimes the survivor is a parent. So sometimes the person who's committing the act of domestic violence is a child. Maybe the child's middle-aged and their parent is elderly. And sometimes we do civil protection orders to protect the parent. Okay, next slide, please. All right, thank you. So I wanted to give you kind of a reference about what are the Ohio Revised Code sites with respect to defining what domestic violence is and what must be proven. And just kind of to go through this one more time, attempting or recklessly causing bodily injury to a family member or placing the family member by threat of force in fear of imminent serious physical harm. And I think one of the key words there is the word imminent, which means, did it happen recently? So at Legal Aid, we accept cases where the domestic violence might have taken place 6 months ago, and we might do a divorce in that kind of case. But for a civil protection order, usually the event, the precipitating event for filing the civil protection order needs to be imminent or, recent in time. And then some other elements that you can go forward with a civil protection order is menacing by stalking or aggravated trespass. And that is patterns of behavior where maybe the perpetrator is following the survivor of violence, following them to their work, following them to their friend's house, and they have a pattern of behavior that they can show, or also patterns of threatening by text, and also following. Next slide, please. Okay, so in a civil case, like a civil protection order or a divorce, you certainly do not have to prove things in a similar way as to how a criminal charge like domestic violence is, but you still, you need to prove it by a preponderance of the evidence, more likely than not. So the reason why I'm pointing that out is a lot of times folks give their testimony, and certainly testimony is some evidence in a trial, but what is also needed is some additional independent objective evidence so that it isn't a matter of he said, she said. Next slide, please. So as I understand it, everyone here is in the helping professions. And so I wanted to give you this tool to think about. One of the things that people who are in the helping professions think about, and certainly we talk about sometimes at Legal Aid, is what's called vicarious trauma. So if you spend your work life helping folks that are experiencing trauma, sometimes you experience anxiety or some trauma yourself, listening, and through your empathy, experiencing feelings about that. So the Domestic Violence Network, where I got a lot of my material for today's presentation, has this handout or this tool for advocates and people who serve folks that have experienced trauma. And so it's important to take care of yourself. And this is kind of a wheel towards looking at your actions, your choices, your resilience, and your ability to replenish yourself. And taking good care of yourself so that then you have that strength and energy to work with others. Okay, so that is, my presentation. I'm happy to take some questions if anyone has any.
So Davida, hopefully some of our participants will chime in with some of their questions about how to help utilize this information in the context of their work. I was going to just ask you to follow up on a couple of topics you touched on, though. And so one of the things you talked about was the legal standard for domestic violence, and in going to court to try to achieve a protection order for somebody, there's some very specific requirements of what has to be proven, right? And I know that in some of my work, I've encountered some frustration or some tension where other advocates, non-attorneys working with survivors, can be really frustrated by that legal standard because it really, it prioritizes physical harm in a way that suggests perhaps the domestic violence that occurs through threats or intimidation or financial exploitation, mental abuse, is somehow not still domestic violence. And I just wondered if you would talk a little bit about that reality and how folks might make sense of that.
Right. So, I feel like, especially like with police officers, when there's a charge of domestic violence, entering the home and being in that situation, it is a heightened, dangerous situation for the police officers. And so when they come into the home and they try to assess like what's going on here, and one person says, well, this is what happened to me. He did this, he strangled me, he pushed me down, he punched me. And then the other partner says, well, that didn't happen at all. She's just trying to gain some kind of advantage because we're getting a divorce. And then the police officer has to look at, is there any physical injury? So going back to my example, like with strangulation, I would say from my reading, most people, if there's a strangulation, they don't have bruises that day when the police officer is looking at them. Many times bruising and things like that shows up the next day. Or maybe the marks are just kind of light. But maybe the injury is in the inside. Maybe it's in the esophagus. That's why medical attention is really important, because there can be, all kinds of internal injuries with strangulation. So that is why it's a tough situation. We have to, we don't have to prove beyond a reasonable doubt like they have to do in a criminal case. We do have to prove by preponderance of the evidence that it is more likely than not that this happened. So again, if it's something that the survivor said and it's something that the perpetrator denies and there's no witnesses, then it's a tough situation. So what do we do at Legal Aid? Like, what do we try to do? Well, we understand that usually there's a pattern of violence. So you'd start out by looking at, are there any witnesses there? Usually this isn't done with any witnesses. Then did anyone, did the neighbors hear anything? You can start out with that. Did the person seek medical help? Did they go to the hospital and seek medical treatment? Did they change their behavior in any way? Does that mean that they altered their way that they drove to work because they were afraid? Or is there a pattern of violence? So maybe the family member saw some bruising around the neck 2 weeks ago. So you indicate, so your client then would testify, 2 weeks ago, I was choked or strangled, I was strangled, or I had a bruising on my cheek, had bruising on my arm. And then there was the most recent incident, and they talk about the most recent incident, and then you call their family member who said, yes, I talked to my daughter about that situation. I saw the bruising on her arm. I took her to the doctor. So I'm not sure if that's answering your question about like the legal standard or what is required to prove. Did that answer your question, Anne?
Yeah, I think it helps. And I don't know if you saw, and we're maybe addressing both what I raised, Davida, as well as the point in the chat. One of our participants just was raising the distinction between clear and convincing and the preponderance of evidence, and it looks like your comments did help respond to her point as well. So thank you for that.
Well, and also we don't set the standard. You know, we don't have
Right.
control over that. You know, that, you know, is, you know,
That's-
we're just, you know, following the case law and the statute.
Of course. So another point I think might be helpful to clarify, Davida, is sometimes when there's both a criminal charge against a perpetrator, so the police do arrest and the perpetrator does get charged with domestic violence, the survivor might be able to get a protection order through that criminal case, which is different from the civil protection order that we're talking about that legal aid pursues. And could you just give a little explanation to what the differences between those two things and why somebody might actually need both in some situations, or when that should be considered?
That's a great question, Anne. So when there are criminal charges pending in one of our cases, we can check in with Howard about this, but I always recommend that you don't file a civil protection order. If there are criminal charges pending, then in my experience, the police are more apt to follow that order, the temporary protection order from the criminal case, than they are a civil protection order. So, and also, if there is a domestic violence case pending, we don't want to interfere with the prosecution of the perpetrator. So if we file a civil protection order, by operation of law, the temporary protection order will be terminated, first of all, so they won't have that anymore. And second of all, then we've brought the issue to another court's attention. A criminal case is usually filed in the municipal court, and a civil protection order case that we file is filed in the domestic relations court. So the CPO then, we would then be bringing to the attention of the domestic relations court all the same things that that prosecutor would be trying to prove in a criminal case. And we actually might put that criminal case in some jeopardy, because the first hearing that's granted ex parte when you file, that's one hearing, but the second hearing to actually have that full order, civil protection order, that's usually set in about 10 days to 2 weeks, and it's a complete evidentiary hearing. So you might be putting the criminal case in some kind of jeopardy if you do that, and you don't have as much time to prepare it, get all the discovery that you need, you know, subpoena that nurse, you know, who saw the person or saw what happened at the hospital and arguing, or all kinds of things that you might need. You really might put that criminal prosecution in some jeopardy. So then what we try to do at Legal Aid is we really try to work closely with the advocate who's helping the person with criminal charges. We work together so that as soon as that case is disposed of, we've got the civil protection order ready. And a lot of times we can't get the proof that we need. We can't get the police report. We can't have the police officer come to our hearing. So it really puts us at a disadvantage. So we don't usually want folks to have that TPO and then right away file for a civil protection order. It can kind of put both cases in jeopardy.
Thanks, Davida. So on a follow-up to that, and Lancherie, if I don't get this right, please feel free to unmute yourself and clarify. But I think the question from our colleague Lancherie is really, if you're relying on the protection order that comes through the criminal case, can a survivor of violence have that cover the children in the household as well? Or would you have to pursue the civil order in order to have the children protected also?
So the judge does sometimes put children on the temporary protection orders in the municipal court cases, the domestic violence cases. There's a lot of discretion that the judges have. Many times they don't do that, especially if the child wasn't injured in the process. It really, really depends on what the facts and circumstances were. I think if we, and I'm not asking you to do this, to go back to my other fatal domestic violence, children were harmed, some children were killed in those situations. So, so children are at risk, and that municipal judge is going to make a decision as to whether the children are at risk, or was this domestic violence primarily between the adults in that situation.
Great, thanks.
Does that answer your question?
I think so. And it reminds me, though, of a different aspect of these cases that can be challenging, certainly for families, which is historically, at least, and I'm afraid this may still be the case sometimes, there are survivors of violence who are afraid to reach out for help because Child Protective Services workers have occasionally used the failure to protect the child as justification for removing a child from their parent. And I wonder if you could just talk about what the best practices are in that area and what we need to be advocating for as a community in terms of not re-traumatizing children and survivors.
Well, that's a really hard question. I'm not sure that I can answer it very well. I mean, part of our assessment process is we do ask our clients whether Children's Services has been involved in their case. And so if Children's Services has been involved in the case, it can muddy the facts with respect to the situation. Sometimes it's not the best time to bring a divorce case if you're gonna, if you want custody. So we try to, just like you said in your introduction, we always try to give some level of advice. So, sometimes we do a civil protection order, sometimes we do a divorce, sometimes we advise under the facts that this is not the time to bring an action like this. If they bring the action at this time with the facts and evidence they have, they might not get the result that they would like to have. So, of course, you don't want to re-traumatize folks, and you want to, we try to take a holistic approach to our clients at Legal Aid. We try to look at how to help our clients have adequate housing when they're leaving the perpetrator, as a stream of income. We try to work on all of these issues, but with respect to the courts, if there are children involved and there's a custody case involved, that survivor does have to be able to provide a safe and adequate home. They have to have enough money to be able to, or help from Job and Family Services to provide enough food, to have beds and other things that they need. And if they don't have some of these things, and some courts will have Children's Services involved in the situation, or they may even allocate custody to the other parent, because sometimes perpetrators of violence do get custody of their children. I don't think I answered that the way you wanted me to answer it, Anne. I'm sorry.
I was not, no, I have no expectations. I asked because I know it's complicated. So I appreciate your just fleshing that out a little bit. And again, I am going to have a couple of more questions, but if folks on the call want to put anything in the chat or unmute yourself and chime in, by all means, please feel free. We're gonna just take about 5 to 10 more minutes if we have additional discussion topics.
Hey, Ann?
Yeah, please go ahead.
It's Howard here. So I just wanted to add a comment. So when there is a situation where there's been abuse, there are what are called sexual assault nurse examiners, SANE, S-A-N-E. And probably the best resource as to where to find one is the Cleveland Rape Crisis Center. I think they have a 24, and they're specially trained to look for injuries that may not be visible, to a lay person. So if someone comes to you, that may be a very good resource to direct them to.
Thank you, Howard. And even though their name is Cleveland Rape Crisis Center, they are providing services throughout all the same counties that legal aid serves. So they have an extended reach as well. Sorry, Davida, go ahead.
No, and I just also, you know, I didn't really touch on the gender issues, and certainly there are more survivors of domestic violence that are women than men. But I just want to point out that at Legal Aid, we do represent survivors of violence that are men. And it's important if your client is a man and he's talking about domestic violence that he's experienced, whether it's same-sex domestic violence or whether that it is a member of the opposite sex. It's very important that we listen to what that person is saying, because I think a lot of times in our society, in our culture, the way that it is, the police really don't want to hear about this man saying that his wife caused him physical injury, and but in fact that happens. And I know, like, I represented a gentleman for several years who he had been assaulted. It was actually felony domestic violence. She had been convicted 3 times of felony domestic violence. And so we represented him in a civil protection order. We represented him in his divorce. And some of these folks, they just really have a lot of, perseverance. And it doesn't matter that they were convicted of domestic violence. They sue for custody. They make allegations of domestic violence themselves. And it's just important to have that understanding that domestic violence happens to both men and women, and to have that empathy for that situation.
Great. So Davida, I thought one other resource that might be helpful to talk about with this group is Ohio's Safe at Home program. Would you mind explaining that? And I'm going to put a link in the chat for folks. Great, thank you.
So I believe it is the Ohio Secretary of State's program. It's called Safe at Home. And clients or folks who have experienced domestic violence will need to actually, it usually, I think here in Lake County, it would be Forbes House, and Jaga it would be Women's Safe, but there are folks who are designated by the Secretary of State's office to help a survivor of violence apply. And what the program is about is to keep their address safe. Sometimes it's difficult to keep your address confidential, even like with a divorce court or a custody case. I remember, this was just last year, I had a custody case in juvenile court, and the other side was trying to require that his client have the address of my client, even though there was a civil protection order. And the juvenile court in that case actually tried to pressure me into disclosing her address. And so in that situation, she had applied for Safe at Home. So we, kind of filed a motion, like with a kind of a memo attached discussing the Safe at Home program. And of course, then the court was aware. So when there's this new program, sometimes the courts don't even know about all of these things. So it's our role as advocates to, inform the courts of these programs to protect survivors of violence.
So another question.
Just say, but you have to apply for it. You have to have a person who's certified, like from Home Safe in Ashtabula, Women's Safe. in Jaga or here in Lake Forbes House, one of those folks has to help you apply for the program. And basically you get a post office box in Columbus. That's why they don't know where you are. And that is where your notices of the hearing, and that's where everything goes.
Thanks, Davida. Could you speak a little bit more about situations where both parties are alleging domestic violence?
Both folks are alleging domestic violence.
Yeah, how would you approach that kind of a situation?
Well, when we do the assessment, we certainly start where our client is and looking at their story. And then, of course, we try to look for that independent objective evidence that supports their story. But also what we do is we ask them, what is the other side going to say about you? What kind of evidence do they have about your conduct? And also we sometimes do docket checks. And so we actually see ahead of time, or probably we always do docket checks for both parties to find out what is their history. And it is actually very common that there's domestic violence convictions for both sides. So what do we do if our client has recent, domestic violence convictions when they have come to us with this situation of domestic violence? And so, sometimes we accept a case like that. Sometimes we don't. We really just try to discern all of the independent objective evidence that applies to that situation. And then also we might kind of put a lens on as to who is the primary aggressor in this situation. You look at who's bigger and stronger, who had the more serious injuries. Why did both people come out with, some injuries in this situation? So then you might offer an explanation for your client's behavior, like self-defense. So yes, my husband pushed me into the wall. I hit my head. He came at me. I punched him to try to get away from him. Maybe I shouldn't have done that, but I did that in self-defense because I thought he was going to hurt me. But whenever there is, that kind of situation that muddies the water, then it is a matter for the court to decide, what is more credible, which side is more credible, what evidence is more credible. And if it is truly mutual combat, that might not be the time to bring that civil protection order. You might not get that civil protection order under those facts.
Right. So we have a really good question posted in the chat, and I'm trying to decide if this one relates more to our next topic of divorce and custody, or if the person is asking about something related to DV specifically in terms of accessing information from Department of Job and Family Services if there's child protective services involvement during the marriage. So, Ms. Rose, my hunch is that would be information that would be accessed in the effort to represent one of the parties in a divorce, and you're about the availability of that, but maybe we'll go ahead and take our break. You can certainly send a chat message to me or just chime in when we come back to our presentation to clarify that if I've misunderstood your question. But at this point, I think I'm going to invite everybody to go ahead and turn off their cameras and make sure you're on mute. If you need to step away from your screens for a little while, get a refreshment,